Greetings. I hope that this video finds you and your family in utmost good health and in good cheer amid these trying times caused by the coronavirus pandemic. This video is created for the benefit of my second-year JMC College of Law students in order to supplement the discussions on the rules on civil procedure. It is my sincerest hope that you would find the discussions herein informative, convenient, or at the very least, helpful. And with that, we proceed. The subject of our present discourse would be the remaining remedy of a petition for the issuance of a writ of certiorari under Rule 65, based on grave abuse of discretion amounting to lack or excess of jurisdiction. Now, what is certiorari? How do we define certiorari? As enunciated in Bovier's Law Dictionary, 3rd revision, page 442, certiorari is a writ issued by a superior court to an inferior court of record or other tribunal or officer exercising judicial or quasi-judicial functions, requiring the certification and return to the former of some proceeding then pending, or the record and proceedings in some cause already terminated, in cases where the procedure is not according to the course of the common law. Further, in our jurisdiction, as provided in Section 1, Rule 65 of the 1997 Rules of Civil Procedure, the remedy is brought against a lower court, board, or officer rendering a judgment or order and seeks the annulment or modification of the proceedings of such tribunal, board, or officer, and the granting of such incidental reliefs as the law and justice may require. Alright, we now proceed to the nature of a petition for certiorari under Rule 65. What is its nature? It should be emphasized that a certiorari is an extraordinary remedy, and being extraordinary in nature, the party who seeks to avail of the same must strictly observe the rules laid down by law. The extraordinary writ of certiorari may be availed of only upon a showing in the minimum that the respondent tribunal or officer exercising judicial or quasi-judicial functions has acted without or in excess of its jurisdiction or with grave abuse of discretion. Likewise, being extraordinary in nature, the acceptance of a petition for certiorari as well as the grant of due course thereto is, in general, addressed to the sound discretion of the court. Alright? Now we go to the requisites or requirements of a petition for certiorari under Rule 65. Now, in the instant discussion, it would be prudent to distinguish these requisites into two: the substantial or essential requisites and the formal or procedural requirements for the filing of a petition for certiorari. In Republic versus Navy Officers Village Homeowners Incorporated, GR number 130008, October 25, 2004, the Honorable Supreme Court elucidates that the petitioner must allege in his petition and establish facts to show that any other existing remedy is not speedy or adequate, and that, first, the writ is directed against a tribunal, board, or officer exercising judicial or quasi-judicial functions. Second, such tribunal, board, or officer has acted without or in excess of jurisdiction or with grave abuse of discretion amounting to lack or excess of jurisdiction. And lastly, there is no appeal or any plain, speedy, and adequate remedy in the ordinary course of law. Let's have a break, class. Let's have a break. We're back. Now, in our present discussion, it would be likewise prudent to distinguish between these terms: without jurisdiction, in excess of jurisdiction, and grave abuse of discretion. Now, as early as 1941, in the case of Cirilo Alafriz versus Mariano Nable et al., 072, Philippines 278, the Honorable Supreme Court already had the opportunity to define and distinguish these terms. To wit, without jurisdiction means that the court acted with absolute want of jurisdiction. There is excess of jurisdiction, where the court has jurisdiction but has transcended the same, or acted without any statutory authority. Grave abuse of discretion, on the other hand, implies such capricious and whimsical exercise of judgment as is equivalent to lack of jurisdiction. Remember this, class: capricious and whimsical exercise of judgment. Or in other words, where the power is exercised in an arbitrary or despotic manner by reason of passion or personal hostility, it must be so patent and gross as to amount to an evasion of positive duty, or to a virtual refusal to perform the duty enjoined, or to act at all in contemplation of law. In relation thereto, it must be underscored that the allegation that the tribunal board or officer exercising judicial or quasi-judicial functions has acted without or in excess of its jurisdiction, or with grave abuse of discretion, will not alone suffice. The allegation will not alone suffice. Equally imperative is that the petition must satisfactorily specify the acts committed or omitted by the tribunal board or officer that constituted or constitutes grave abuse of discretion. Again, by way of review, the essential requisites in order for a petition for the issuance of writ of certiorari to prosper are: first, the writ is directed against a tribunal, board or officer exercising judicial or quasi-judicial functions. Second, such tribunal, board or officer has acted without or in excess of jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction. And lastly, there is no appeal or any plain, speedy, or adequate remedy in the ordinary course of law. Question: what if an appeal was available and that through the aggrieved party's negligence the appeal was lost? Now, can the said aggrieved party then avail of a petition for certiorari under Rule 65 based on grave abuse of discretion amounting to lack or excess of jurisdiction? As a general rule, the answer is no. In a gatina of cases, the Honorable Supreme Court has emphatically held that where appeal is available to the aggrieved party, the action for certiorari will not and never be entertained. Remedies of appeal and certiorari are precisely mutually exclusive and not alternative or excessive. Hence, certiorari is not and cannot be a substitute for a lost appeal, especially if one's own negligence or error in one's choice of remedy occasion such loss or lapse. Now, another query: is the submission of a motion for reconsideration required to avail of the remedy of a petition for certiorari under Rule 65? The answer is yes. It is required. The settled rule is that a petition or a motion for reconsideration is a condition sine qua non for the filing of a petition for certiorari. Indeed, one has to file, as a general rule, a motion for reconsideration before one can avail of a petition for certiorari under Rule 65. Precisely, its purpose is to grant an opportunity for the court to correct any actual or perceived error or errors attributed to it by re-examination of the legal and factual circumstances of the case. Again, class, the petitioner has to file a motion for reconsideration before the latter can avail of the remedy of a petition for certiorari under Rule 65. However, as with all things, this rule admits of some well-defined exceptions as follows. First, where the order is a patent nullity, as where the corta quo has no jurisdiction. Second, where the questions raised in the certiorari proceedings have been duly raised and passed upon by the lower court or are the same as those raised and passed upon in the lower court. Third, where there is an urgent necessity for the resolution of the question and any further delay would prejudice the interests of the government or of the petitioner, or the subject matter of the action is perishable. Fourth, where under the circumstances a motion for reconsideration would be useless. Fifth, where the petitioner was deprived of due process and there is extreme urgency for relief. Sixth, where in a criminal case, relief from an order of arrest is urgent and the granting of such relief by the trial court is improbable. Seventh, where the proceedings in the lower court are a nullity for lack of due process. Eighth, where the proceedings were ex parte or in which the petitioner had no opportunity to object. And lastly, where the issue raised is one purely of law or where public interest is involved. Take note of these exceptions last. Now, another question. When do you file a petition for certiorari? What is the reglementary period? When do you file it? Section 4, Rule 65 states that the period is not later than 60 days. 60 days from notice of the judgment, order, or resolution sought to be assailed, or 60 days from notice of the denial of the generally required motion for reconsideration. Another query. Where do you file a petition for certiorari under Rule 65? Which court has jurisdiction? This is likewise answered by Section 4 of Rule 65, which provides that the petition shall be filed in the Supreme Court, or if it relates to the acts or omissions of a lower court or of a corporation, board, officer, or person in the regional trial court exercising jurisdiction over the territorial area as defined by the Supreme Court. It may also be filed in the Court of Appeals, whether or not the same is in aid of its appellate jurisdiction, or in the Sandigan Bayan, if it is in aid of its appellate jurisdiction. Now, if it involves the acts or omissions of a quasi-judicial agency, unless otherwise provided by law or these rules, the petition shall be filed and cognizable only by the Court of Appeals. However, please remember, class, that this is subject to the doctrine of hierarchy of courts. You remember that doctrine, class? That came out in our first exam. Alright? By way of review, the doctrine of hierarchy of courts states that where the courts have concurrent jurisdiction over a subject matter, such as a petition for certiorari, the case must be filed before the lowest court possible, having appropriate jurisdiction. Except, as in all things, there is an exception. If one can advance a special reason, which the court or which would allow direct recourse to a higher court. Special reason. Now, with Section 4 of Rule 65 and the doctrine of hierarchy of courts in mind, as a general rule, orders, resolutions, etc. of the municipal trial court, you file the petition for certiorari with the regional trial court. Orders, resolutions of the RTC, generally, you file it with the Court of Appeals. Orders and resolutions of the CA, you file it with the Supreme Court. Now, query, how about those orders or resolutions of tribunals or agencies exercising quasi-judicial powers? As a general rule, unless otherwise provided by law or these rules, you file the petition for certiorari with the Court of Appeals, pursuant to the express provision of Rule 65, Section 4. Let's have another break, class. Thank you. Alright, let's continue. Let's proceed to the formal or procedural requirements of a petition for certiorari under Rule 65. Now, these are, first, the petition must be verified. Second, it is filed not later than 60 days from notice of the judgment, order, or resolution so to be assailed, or 60 days from notice of the denial of the motion for reconsideration. Class, remember that this period is, as a general rule, non-extendable. Now, third, the petition shall contain the full names and addresses of all the parties, the factual milieu, the surrounding facts and circumstances, the grounds relied upon, and the relief prayed for. Fourth, the petition must be accompanied by the duplicate originals or certified true copies of the award, judgment, order, resolution, or ruling subject thereof. And lastly, the petition must contain a sworn certification against forum shopping. Alright? And with that, class, we conclude our discussion for this video. I would like to express my gratitude for your time in attending the present discourse, and I hope that the discussions herein have been fruitful and or otherwise productive. Thank you, class, and good luck on your exams. Thank you.